We'll be looking at what a miscarriage of justice is, some case examples, and how they can be prevented in future.
Here's a short summary of a miscarriage of justice. The definition of a miscarriage of justice is a failure of a court or judicial system to attain the ends of justice, especially one which results in the conviction of an innocent person. A miscarriage of justice can be defined in several different ways. Most commonly, it refers to the conviction of a person in a court of law for a crime of which he or she is later proven innocent. A miscarriage of justice can also apply in the reverse manner, that of a guilty person being set free when there is overwhelming evidence or later proof that he or she was actually guilty of the crime of which they were accused of. The phrase is not solely restricted to crimes against persons or property, for it can also apply to civil cases where punishment consists largely of financial compensation. In short, a miscarriage of justice is any situation where an individual is somehow incarcerated, executed or punished due to the error of the legal system. Lord Phillips gave his own definition of miscarriage of justice. He stated, miscarriages of justice is a phase that is capable of having a number of different meanings. I shall summarise in my own words. A. Where the fresh evidence shows clearly that the defendant is innocent of the crime of which he has been convicted. B. Where the fresh evidence is such that, had it been available at the time of the trial, no reasonable jury could properly have convicted the defendant. C. Where the fresh evidence renders the conviction unsafe, in that, had it been available at the time of a trial, a reasonable jury might or might not have convicted the defendant. And finally, D. Where something has gone seriously wrong in the investigation of the offence, so that the conduct of the trial will result in the conviction of someone who should not have been convicted. How does a miscarriage of justice occur? Miscarriage of justice can result from non-disclosure of evidence by police or prosecution, fabrication of evidence, poor identification, overestimation of the evidential value of expert testimony, unreliable confessions due to police pressure, or psychological instability and misdirection by a judge during trial. Now you know how a miscarriage of justice occurs, you might be asking yourself the question, how is it being prevented? Since 1984, 2 pieces of legislation have been introduced in an attempt to prevent any miscarriages of justice. The Police and Criminal Evidence Act, also known as PACE, gave detectives rigid rules on how long they should question a suspect for, and insisted interviews should be taped to ensure that there's no mistreatment or undue intimidation. The Criminal Procedure and Investigations Act was also introduced in another attempt to make sure that the police or the Crown Prosecution Service, which is also known as the CPS, disclose to the defence everything which they think is relevant to the case. The Criminal Cases Review Commission, also known as the CCRC, is an independent public body that was set up in March 1997 by the Criminal Appeal Act 1995. Their purpose is to review possible miscarriages of justice in the criminal courts of England, Wales and Northern Ireland, and they refer the appropriate cases to the appeal courts. Kevin Collin, Dave Wood, Adrian Mather, Graham Huckabee, Shay Power, Suzanne Holdsworth, Ian Lawless and Martin Farron are all supported by Innocent. It's a group which meets every month in Sheffield to support people who are wrongly convicted prisoners. It's funded solely by members of the group, and it's also supported by one of the Birmingham 6 members. A bit of background for miscarriages of justice is that campaigns surrounding individual cases began in the 1980s, when British people became discontent with the British criminal justice system. There were 2 main cases which the term miscarriages of justice seemed to revolve around, and that's the Birmingham 6 and the Guildford 4, both of which were IRA outrages against civilian targets at the height of the bombing campaign.
In 1996, a young girl was out partying in a nightclub in Redditch. Later that night, she was raped outside the club before the attacker ran off. It was put forward to the police that the attacker had been in the nightclub that evening and was described by witnesses as having a Scottish accent and a noticeable lump on his forehead. Victor Neelan was convicted of attempted rape in 1997. The The circumstances that led to this conviction were quite simply an ID parade which Nealon readily volunteered for. Nealon offers his DNA so that testing on the evidence, including the victim's clothing, could take place. Also, his partner at the time confirmed Nealon's alibi that he was at home with her and her daughter watching movies that night. Each of the circumstances has a failure. The ID parade was attended by a police officer involved in other areas of the case, a conflict of interest perhaps. No DNA testing ever took place. In fact, the evidence remained in its sealed bags, and finally, due to the partner and her daughter's inability to exactly match the order of the movies viewed, this was seen as a weak alibi. The prosecution presented evidence at a point in the trial whereby Nealon was unable to answer for it or dispute it. Nealon was sentenced to 7 years imprisonment for the rape of a female. During his imprisonment, Nealon appealed to the CCRC twice. Both times his request was denied, the CCRC claiming that they would not perform speculative testing on evidence. None of the evidence had been tested when the case first went to trial in 1996-1997, but had remained in the sealed bags. The third appeal was successful in getting the evidence tested for DNA samples, where it was found that Nealon's DNA did not appear on any of the items. By this point, Nealon had served 17 years for a crime for which he refused to admit guilt or be rehabilitated due to his insistence that he was innocent. Had the DNA testing took place, Nealon would not have lost all those years in HMP Wakefield. On December the 13th, 2013, Victor Nealon was released, his conviction quashed. He was given £46 and a train ticket to Shrewsbury with no home and no place to stay. He spent his first night on the streets.
A man who was wrongly
Following this
convicted
ordeal,
of
Nealon was
attempted rape has
appealing
been
for
freed by the Court of Appeal
compensation
after spending nearly 17 years in prison. Victor Nealon, who was 53 and from Worcestershire, was arrested after a woman was sexually assaulted in Redditch in 1996. The case was referred back to the Court of Appeal after tests on the victim's clothing found traces of DNA from another man. This was how the Court of Appeal announced today's decision.
For reasons which are going to be reserved and handed down next term, this appeal is allowed, and we quash the convictions.
Chris Grayling, the Justice Secretary, has denied Nealon any financial award for the loss of 17 years, claiming that even though DNA evidence shows up as another male, it is not wholly conclusive that Nealon did not commit the crime. In other words, Grayling is suggesting that despite protesting innocence and having that innocence confirmed by lack of solid evidence, Nealon could still be guilty. Mark Newby is a head of miscarriages of justice and crime team in a Doncaster solicitor, specialising in appeals and applications to the Criminal Case Review Commission. He has delivered speeches at Innocence UK conferences and has also written articles for legal information webpage The Justice Gap. He is representing Victor Nealon in his appeal for compensation. Michael Norton has spearheaded the Innocence Network and its work with wrongfully convicted prisoners. He does indeed highlight that there is a difference between wrongful convictions and alleged wrongful convictions, in that it only becomes known as a miscarriage of justice once the appeal courts have decided such. Norton talks of Victor Nealon's case where it could be said that the victim of the crime is also a victim of this miscarriage of justice because they have spent almost 20 years believing that the person that attacked them has been in prison, only now to discover that the real perpetrator has been free. This is enough to unnerve any person, let alone the victim of such a horrific sexual attack. Norton in 2010 examines the key causes for wrongful convictions, which include things such as false allegations, incompetent police investigation and prison informants. In Victor Nealon's case, the main causes under Norton's theory are non-disclosure of vital evidence, DNA was not tested against the items of clothing, incompetent police investigation, he did not fit the description, Nealon is Irish and had no lump to the forehead, and also the ID parade's credibility is disputable due to the presence of a particular officer. Norton further explains the CJS's flaws in overturning wrongful convictions, highlighting how the Court of Appeal is only looking to determine whether a conviction was safe or unsafe. This relies heavily on introduction of new evidence, or in Nealon's case the testing of old evidence that was never put forward. Under the Criminal Appeal Act of 1995, whether a person is factually innocent or factually guilty is not the main concern. As a result, some victims of wrongful convictions may never see the ruling overturned if they are unable to provide new evidence or prove the instability of previous material. Victor Nealon was eligible for parole 10 years prior to his release. However, as Norton explains, prisons are meant for the guilty, not the innocent. This means that for a person to be granted parole, they must show the parole board that they are remorseful and rehabilitated. Nealon was neither, because he was sure of his innocence. He even admits at one point that he considered admitting guilt simply to be released, but he was determined to have his conviction overturned and his innocence accepted.
In conclusion, you can apply for compensation if your conviction has been overturned or quashed by the court and your appeal was successful and it was submitted 28 days or more after your conviction, or 21 days or more after a conviction in a magistrate's court. Your conviction was overturned after it was referred to the Court of Appeal by the CCRC, or you've been granted a free pardon. The Ministry of Justice turned down a claim by Victor Nealon and said there was no automatic right to compensation. Claims are dealt with on a case-by-case basis. This shows although cases are quashed and recognised as a miscarriage of justice, not all people are as fortunate as the Birmingham Six, who were compensated to a degree and repaid for the time they spent incarcerated. This raises a question as to whether the current system is fair and just, and it highlights definite areas of improvement in the criminal justice system in regards to miscarriages of justice.